Okay, so thank you all for being here again. I hope we have a really thought-provoking conferences today and tomorrow. So to begin with, I introduce Professor Karl-Peter Sommermann, who will talk about the dimensions of the principle of solidarity in the European Union. Professor, please. I will place your slide.
Thank you, it's even nicer. Yes, welcome everybody. It's a great pleasure to be here. Agradezco mucho a la cátedra, profesor Saiz, de invitarme, a la profesora Maribel González Pascual. Nos conocemos ya desde hace mucho tiempo, alegría de verle. Y muchas gracias también a los organizadores, coordinadores de este seminario, la profesora Aida Torres y el profesor Marcelo Lozada. The subject of today are social rights. In my presentation, they will play a little minor role because it's part of an overarching view on the principle of solidarity in the European Union. My presentation, I have structured it as follows: a short introduction to the conceptual background. I think it's always useful to see this. Where is this idea of solidarity based on in the European Union? And then I want to elaborate on the 3 dimensions. Others have found 4 dimensions. I have found 3 dimensions. Afterwards, I will also address the topic crisis of solidarity in Europe, which you can find in many books nowadays that have even the title. So first, the concept. The term solidarity emerged as a guiding concept of social and political philosophy in the 19th century. Although it has been used in different contexts, 2 elements can be identified as a starting point. The first one is and this is often forgotten, the mutual recognition of the individual autonomy. First of all, you have here actors who give a certain recognition on each other. And on the second point is the awareness of the mutual dependence of the members of a given community on the other hand. From these prerequisites, a moral imperative to grant mutual assistance has been deduced, including deontological as well as utilitarian approaches. So you can also argue that solidarity is something you do in your self-interest. This would be very utilitarian, while the deontological approach would be it's a special value. We want to do this irrespective of self-interest. Irrespective of the epistemic or moral origins, the principle of solidarity has later been introduced in the legal sphere, also in the law of the European Union. Since France was a shaping force behind the introduction of the concept of solidarity in the institutions of European integration, it is useful to take a look at how it developed in this country from an analytical concept of empirical sociology to a normative principle of political and constitutional theory. Among the sociological studies on solidarity, the most influential was the treatise De la division du travail social by Emil Durkheim, published in 1893. Durkheim identified solidarity as the constituent principle for every society. He distinguishes 2 categories of solidarity. On the one hand, the mechanic, or we may say natural solidarity. On the other hand, the organic, or we might say modern solidarity. The first one, the mechanic solidarity, la solidarité mécanique ou par similitude, is characteristic above all for traditional homogeneous societies tied together by a common religion or similar convictions and lifestyles. The second one, which is more interesting here in our context, is the organic solidarity, la solidarité due à la division du travail ou organique, that can be found in modern heterogeneous pluralist societies. Here, solidarity grows out of the division of labor. The members of society thus find themselves in a relationship of interdependence, exchanging their contributions to the community. This perception in daily life creates a feeling of solidarity, un sentiment de solidarité, and entails the development of moral standards that strengthen the functioning of a society. So it can be concluded that in the long run, a feeling of solidarity is indispensable for the integration of a pluralist society. Taking into account that solidarity is primarily an empirical phenomenon, un fait social, says Durkheim, including even an emotional aspect, it is not evident that solidarity is suitable to be prescribed by law. Quite to the contrary, social scientists will show that solidarity among citizens cannot be enforced and depends on the individual value orientation and readiness to help. It has to develop over time. However, solidarity as a societal and legal principle is not necessarily to be understood as a concept which depends on subjective personal attitudes of the individual. Already Durkheim had characterized the social solidarity as an entirely moral phenomenon. And under morals, I mean general rules which are not necessarily accepted in an ethical sense by the individual, but as a moral rule. It was Léon Duguy who incorporated the assumptions of Durkheim in a theoretical framework of constitutional law. The great fact of solidarity, or as he says, social interdependence, le grand fait de la solidarité ou l'interdépendance sociale, he wrote, leads in a first step to acknowledge a corresponding social norm, which has to be complied with by all individuals. In a second step, he argued that this fundamental principle must be the basis of law as well, which means that the state has to adopt laws that concretize or materialize the principle of solidarity. Furthermore, the state has to use its power and means to make solidarity a real phenomenon in society. This consideration leads him to link the principle of social interdependence or solidarity with the concept of service public. As you know, if you like, we can talk more about that. This is the social dimension in the case of Duguy. In line with the assumptions of Durkheim and Duguy, Jean Monnet and Robert Schuman put in the center of their concept for European integration the principle of solidarity. Their approach can be characterized as institutional engineering insofar as they relied on the transformation of the relationship between the European nations by a common institutional framework. The creation of common European institutions, the establishment of concrete procedures of cooperation, later a common market, should create step by step a feeling of solidarity among the peoples of Europe and thus lead to a united Europe, a European society. According to the famous words of Robert Schuman, Europe is to be built through concrete achievements which first create a de facto solidarity. This sentence everybody of you knows is this famous de facto solidarity, creating de facto solidarity. This is Durkheim in a nutshell, if you like. It's not something conceptually completely new. I come to the second part of my presentation, the basic dimensions of solidarity in the European Union. The formula of Robert Schuman that the creation of de facto solidarity stands at the beginning of European integration was introduced in the preamble of the treaty establishing the European Coal and Steel Community. Solidarity is also invoked in the preambles of the treaty establishing the European Economic Community and the Treaty of Maastricht. In Article 2 of the present Treaty on European Union, solidarity is addressed as a common societal value. This is very interesting because people say this is Article 2 says it's a general value of the Union. This is right, but also a bit wrong because it's here as a societal value in the member states. Reference to the principle of solidarity is also made in other provisions of the primary law of the European Union. Taken together, they open up three dimensions of the principle of solidarity in the European Union. You can see it here: solidarity among member states, solidarity with third countries or international solidarity, and social solidarity. I start with solidarity among member states. The European Court of Justice has early recognized that solidarity between the member states is an underlying fundamental principle of the European Union. Article 21 of the Treaty on European Union confirms the opinion of the Court when it refers in the context of the Union's action on the international scene to the, I quote, principles which have inspired its own creation, mentioning solidarity in the subsequent enumeration of principles. The jurisprudence of the European Court of Justice reveals that solidarity in the context of the treaty law is first of all conceived as the readiness and the reliability of the member states to comply with the common rules and principles of the community, nowadays of the Union, regardless of adverse national interests. So you must comply with these rules and not ask, are they good for me or not? Once they are adopted, you have this obligation. Otherwise, mutual trust, the basis for further integration, cannot grow. However, if solidarity was limited to the mere fulfillment of the obligations arising out of the treaties, the principles of mutual assistance and burden sharing, inherent to the idea of solidarity and reflected in several treaty provisions, would remain absent. Therefore, the question follows: if the general principle of solidarity can serve as an independent legal basis for the deduction of further concrete obligations of the member states. Whereas rights and obligations laid down in the Union law surely have to be interpreted in the spirit of solidarity, there is no automatism to derive from this principle new specific obligations and rights. According to the still prevailing principle of conferral, the Union shall act only within the limits of the competences conferred upon it by the member states in the treaties to attain the objectives set out therein. From this follows that the European Union may only adopt or require measures of solidarity which can be based on specific competences laid down in the treaties. And if we look at the treaties, there are several specific references to solidarity. With regard to international relations, the TEU emphasizes the development of mutual political solidarity or mutual solidarity among member states, all quotations from the treaty. Solidarity between member states or solidarity and fair sharing of responsibility is guiding principle in the common policy on asylum, immigration, and external border control even. Furthermore, severe difficulties that rise in the supply of certain products, notably in the area of energy, will be dealt with in a spirit of solidarity between member states. In the realization of the objectives of energy policy, and if a member state is the object of terrorist attack or a victim of natural man-made disaster, it is also valid. These are only provisions where you find explicitly you have to include in a deeper analysis all the other mechanisms and institutional arrangement that also provide for solidarity obligations. Look, for example, at the European Regional Development Fund and others. They are reflecting this principle of solidarity. The survey of the legal situation shows that the general principle of solidarity is widely spread in the EU treaty law, however not automatically deemed to convey concrete duties to act. Second, solidarity towards third countries, non-member countries. Article 3, paragraph 5 lists among the objectives of the European Union to contribute to solidarity and mutual respect among peoples, an imperative from which logically follows the duty of a respective behavior of the Union itself. Solidarity towards a specific group of third countries is explicitly addressed in Recital 7 in the preamble of the Treaty on the Functioning of the European Union, when it speaks of the solidarity which binds Europe and the overseas countries. I want to abbreviate here a bit my presentation, just mentioning that you find in the treaty, of course, other, let's say, explanations of solidarity with third countries, normally specific groups which have special links to European Union members. Above all, the agreements between the EU and African, Caribbean, Pacific countries and regions. Third, social solidarity. The solidarity among members is a phenomenon of, we may say, aggregated or collective solidarity, member states, not of individuals, but aggregated solidarity. However, the more the idea of a Europe of citizens has developed, the more the concept of solidarity has been extended to solidarity among citizens as well. The social policy, originally aiming at the equalization of competitive conditions, has become increasingly the objective of a social Europe. The reference which is made in Article 151 to international social rights instruments and the creation of a European Social Fund indicate this tendency. Above all, it is nowadays Title 4 of the Charter of Fundamental Rights of the European Union that stands for the principle of social solidarity. I'm sure you have discussed this already at large. Headed Solidarity, Title 4 enumerates a wide range of social guarantees. In the perspective of the European Commission, solidarity between member states and social solidarity are closely interrelated. This is an important point. I'll come back to this later when we look at the program of President Macron. This becomes particularly clear in the communication from the Commission of the year 2008. I just read 2-3 sentences of it. I quote the Commission: Europeans share a commitment to social solidarity between generations, regions, the better off and the less well off and wealthier and less wealthy member states. Solidarity is part of how European society works and how Europe engages with the rest of the world. Real equality of opportunity depends on both access and solidarity. Solidarity means action to help those who are disadvantaged. And then later it refers to the fostering social inclusion and integration, participation and dialogue, and combating poverty. So we can see the Commission opens up here a scenery which does not distinguish any longer between the mere solidarity between member states, but enters in the social dimension of it in the European societies. As far as the implementation of this renewed social agenda is concerned, the Commission advocates cooperation of the member states on the basis of the open method of coordination, thus extending the realization of the principle of solidarity beyond the sphere of mere supranational law. So it's a task which really goes further. My third part: is there a crisis of solidarity in the European Union? Question mark. Having reviewed the range of solidarity requirements enshrined in the EU treaty law, we have to clarify why or to what extent it might be justified to speak of a crisis of solidarity, a widespread assessment of the recent years. It is certainly not enough to hint at the political controversies about the scope and fulfillment of the duties arising out of the general principle of solidarity. This is a normal phenomenon, since duties of solidarity, if not legally concretized, are in many situations hardly to define. It's more or less a certain attitude also of states to act and in means of interpretation and so on. However, the recent discussions hint at a deeper disenchantment or even distrust of the EU member states related to a loss of readiness to grant mutual assistance and support and to comply with the rules and principles common to all member states, even if they might affect national interests. The great challenges for European solidarity came up in the last decade, originating, you all know these points, first of all from the financial crisis and from the refugee crisis, later from the questioning of fundamental values by single states, Poland, Hungary, but potentially also in further member states where a rise of populist political movements and parties can be observed. So we should not only have our view always on Poland and Hungary, we have similar risks and dangers coming up in other countries. And thirdly, from the present risk of disintegrating effects emanating from the so-called Brexit. I start with the management of the financial and refugee crisis. The financial and refugee crises, widely regarded as having triggered the solidarity crisis, show, from the legal point of view, two important differences. As far as the refugee crisis is concerned, it occurred in a policy field that should be governed according to treaty law by, I quote again the treaty, solidarity and fair sharing of responsibility, and finds a legal framework in a common European asylum system consisting of several instruments of secondary legislation. In case of the financial crisis, no similar solidarity imperatives can be found in treaty law. Quite the opposite. The non-bailout clause of Article 125, paragraph 1 of the Treaty on the Functioning of the European Union even seems to exclude any financial assistance or assumption of commitments of other states. The rationale behind this position is clear. It is directed against what is called in economic theory moral hazard, which means it is to avoid that a member state conducts a risky or even irresponsible financial policy only because it can be sure that other member states will pay for the risk in the last resort. Under the pressure of the debt crisis, the rigorous line was mitigated. First, a European Financial Stability Facility was set up soon in 2012, equally on the basis of an international treaty, the European Stability Mechanisms, shortly before Article 136 had been amended in order to confirm that this is a possible way in union law. This mechanism, the European Stability Mechanism, permits to grant loans with low interest rates to member states in need under the condition that they conduct a sound financial policy. The criteria for this policy are laid down in another treaty, the European Fiscal Compact, which is, you know it perhaps under the word Treaty on Stability, Coordination and Governance in the Economic and Monetary Union. And there you have numerous criteria which also entailed amendments in several constitutions, also in Spain afterwards, to stop, to get more depth. One of the 2 or 3 modifications of your constitution since 1978. No? This, Germany also, we had also change and so on. The criteria for this policy are laid down in this treaty. The link between the granting of loans and the fulfillment of certain criteria of fiscal policy, this conditionality, is to minimize moral hazard effects. Here you can see it again, the aspect is here, and they have found a certain way to minimize this effect. Recital 5 of the preamble of the ESM Treaty declares that this treaty and the Fiscal Compact, both together, I quote, are complementary in fostering fiscal responsibility and solidarity within the economic and monetary union. Both sides. Nevertheless, the whole mechanism remains ambivalent, primarily aiming at the stability of the monetary union, and if you like, I would characterize it as a kind of self-interest-driven solidarity. The intents to find new mechanisms for the burden sharing in the refugee crisis have not yet been successful. Essentially, 2 factors contribute to the difficulties to find a sustainable reform in the refugee case. First, the loss of confidence in the old Dublin mechanism, which has been considered to be unfair towards the member states with external borders to third countries or to the sea, to the Mediterranean in particular. Even people have spoken of burden shifting instead of burden sharing. That means certain states, and this does not construe a lot of trust afterwards. Second, different opinions on the asylum policy is another factor within the member states, with a particular restrictive position of the Visegrad states. So we can see in this field there is nearly no basis for the time being for action in solidarity. We have to state that, and the European Union now, the different institutions are in search of a solution which might bring back certain trust and a new solution. And we can state here that a symptom of crisis really can be stated here indeed. Second point, the questioning of fundamental values of the Union by single member states. Among the group of the Visegrad states, there are two states they are openly questioning fundamental values of the Union, Poland and Hungary. In both countries, reforms are putting into question rule of law requirements and fundamental rights protection. To date, neither the dialogue procedure of the Commission nor the initiation of the procedure according to Article 7 of the Treaty on the European Union have made change the positions of both states, and what is more, the President of Hungary has declared that he would veto any statement on the violation of fundamental rights by Poland. So the possibilities of the Union to protect the common basis of values is very limited. Infringement procedures before the European Court of Justice, which the Commission meanwhile has initiated in 2018, may be helpful but will not resolve the fundamental problem. Once fundamental values are not respected by several states, the mutual trust will erode and thus destroy the basis of solidarity. We also have here one of the really important prerequisites putting into danger the presence of solidarity in the Union. Last point, very briefly, because I suppose that we will have still other, the ongoing effects of the Brexit. As far as Brexit is concerned, it is not yet clear if it will disintegrate the Union as a whole or if it will, quite to the contrary, strengthen the solidarity of the remaining state. We have observed that in the negotiations, the Union, until now, showed a certain solidarity among the remaining states. That means there were no, let's say, divergent opinions how to negotiate. Up to now, it was quite coherent. And I also want to recall that Article 50 of the Treaty on European Union was introduced also in order to exercise a disciplinary effect. Article 50 was introduced, and I think one of the effects was that states that criticized always the Union, although they were members, they could be hinted at the fact, if you think it's so bad, everything is so awful, you can leave Article 50. Yeah? You can trigger Article 50 and you can get out. So the idea was to discipline these states before always criticizing, trying to change things and stay. However, I think at that point, not all states have thought that a member state really would trigger Article 50. But I think it's a positive norm because really those who do not want to stay, and they have a possibility to go out. The fact that the procedure, how to withdraw, is quite complicated, has not been, let's see, previewed how it was now, and we will see if there comes a sound solution. So normally the states, at least that stay, have to stick to the principles of the European Union. My last part, how to strengthen solidarity in the European Union. So the present crisis of solidarity raises the question if the approach of the founding fathers and mothers to integrate by creating a de facto solidarity has been or will be successful. On the one hand, it has apparently made possible great progress in view of a political union. On the other hand, when EU legislation that becomes always more intransparent for the union citizens is perceived as unfair, this will diminish trust and solidarity. So you create more facts by law, but be careful if people cannot understand it or have the impression that it's unfair, it can have adverse effects. Some politicians see a solution in a deeper integration now. President Macron wants to deepen, in particular, the social integration. You remember, the Commission said, solidarity between member states and social integration is interwoven. So the idea is more social solidarity will also improve solidarity among member states. Another field is defense, to make more for the common security. The President Macron in France seems still to stick to Durkheim, Duguay, and Schuman. I have read in one of his objectives of his program, Objectif 3, renforcer l'identité européenne par des réalisations de fait. So he still sticks to this de facto solidarity which will develop when I change the surroundings, when I change institutional arrangements and so on. So we might ask, is this the right way? It's ambivalent, I would say. When you come to a very sophisticated system which is so differentiated that people have difficulties to understand it, it is also difficult to awake solidarity in such a system where nobody feels at home, in a sense. And something, I think, it's not only the law where we have to look at. I'm a lawyer, but I'm not convinced that the final solution lies in the law. I want to recall a saying of a German state theorist, constitutionalist who 3 weeks ago has died, Ernst Wolfgang Böckenförde. He said something very famous. Every lawyer in Germany, public lawyer, knows that. He said once, the liberal constitutional state lives from preconditions which the state itself cannot guarantee. And I would transpose this on the level of the union. Finally, the union cannot, by developing law, by making laws, by changing the treaties, guarantee that the prerequisites in the populations, in the peoples, will afterwards really be present in the system. So we have also to develop this kind of European political culture. I think this is very important, and these are tasks for many political parties and the Europeans who still exists in our countries. That's all. Thank you.
Professor Sommermann, thank you so much for your excellent explanation about the solidarity principle. Now it's the turn of Professor Dagmar Schiek, who will explain the following presentation. Has economic and monetary union fundamentally altered the EU's socioeconomic integration model? Reflection specifying the impact of post-crisis new economic governance on social integration. So, please, Professor.
Yeah, thank you. So, can I manipulate my own slides, or how do we do this?
Well, I think you could do it.
If we change place?
Yeah,
If that's all right, yeah.
No, I think it's
It's
better.
the wrong slides. These are not the right slides.
Oh, this is right here.
These are my slides, yes. That's the wrong
Yeah.
slides.
That could be fun. We could get people to present each other's papers.
Yeah, well, I'm not sure I'm up to presenting your paper, Claire.
It's not mine, it's Paul's. It was Paul's.
Okay. Okay, in this case, this is the good slides, and you've seen that I've also slightly changed the title, which is very indicative of my paper being quite provisional and much less professorial, and stating, I'm more asking, will the I'm still considering economic and monetary union as a fundamental challenge to the EU's socio-economic model, and the question is, how can we overcome this challenge? And I'll have some reflections on the future of social rights. I have to say up front that this work is based on common work with Sara Clavero, who was a research officer in my Jean Monnet chair, our Jean Monnet's Center of Excellence. And so we're still working on a paper on this field, and we'll develop it in different areas. And this part will then go into your publication here. All right, so the main argument I'm going to make in this paper is up here in the corner, also indicating its provisionality. So I think if the EU is to regain any legitimacy, I think it has a bit of a crisis of a legitimacy lately, while also continuing its internal market project, which is a constitutionalized economic integration project. It will need to proceed to a new appreciation of the relation of social integration and economic integration. It shouldn't be considered as something which is in tension, contradictory, and ultimately excluding each other, but rather we should recognize that there's a dialectic relationship between the economic and the social. And to put this a bit less academic, on a lower level perhaps, where there can't be any society without economy, but there can also be not an economy without society. And that is what I mean by a dialectic relation. So far, law and politics associated with social Europe are normally not seen as fixed, hard, enforceable, full taught. Their home is soft governance, new governance. And social Europe needs to proceed beyond that stage if the EU is to regain its legitimacy. That's a big claim. I don't make all this claim in this paper. I'm going now very lower and look into a bit of these, what is the EU's socio-economic paradigm and how it is realized, how it can be contained in the internal market, and why EMU is so much more a severe challenge to the socio-economic paradigm underlying the EU's integration process. And I go a bit into the original design faults, though I'm a bit afraid of doing this because I know that your center is so much specialized in the design faults of EMU. At least you'll find the faults in my design faults. And I then will go a little bit into the new economic governance. And when I'm looking into the European pillar of social rights, I won't look into the whole pillar because Claire's going to do this in her paper, I think, or some of it. And I'll focus on a special problem, which is a long-term care of people needing care as an example. So let's see how far I get with that in half an hour. And now my slides have gone already on this computer. Sorry about this, but I can still say it. So, well, sometimes that happens. So the EU socio-economic model rests on normative paradigms, in other words, the treaties. And the treaties have always said the EU pursues a goal of harmonizing the living and working conditions with an upward trajectory. So that's my English summary. The wording of the treaties is well known. I don't need to repeat that. Now, today's treaties are going a bit further. So this has been from 1957. So one of the aims and the purpose of the EU has been to improve living and working conditions, and all the way harmonizing the living and work conditions at the same time. Today's treaty are a bit further, so they pursue social justice, full employment, competitive social market economy, non-discrimination, gender equality, sustainability, but they also support competitiveness and the internal market as such, the right of business to act in the market and so on. Rosas and Amati call this a chameleon, so the internal market with them is liberal for yellow, green for sustainability, and red for social justice. And what is it, they ask. So this can be achieved, and I think actually I did find a link to the previous chief speaker here, which I didn't expect. This can only be achieved if there is an interaction between the European level of things and law and the member states levels. So there must be not only an interaction between the economic constitution and social integration, but also an interaction between the member states' economic policy and national social constitutions with the European integration project. Now, Before 1993, which is when Economic and Monetary Union was introduced, yeah, there was a precarious balance which had been achieved and was acting out. So at the EU level, there's a relatively strong economic constitution. The internal market law guarantees the economic freedoms, guarantees competition law, can be enforced judicially, which has been criticized, yeah. And that enforces judicial enforcement of the economic freedoms and competition rules can then challenge national institutions at national level which serve social integration. One of the earliest fields of case law where that took place was healthcare law, where national institutions, social healthcare insurances were required to accommodate claims of citizens of other states. And then later on, there were challenges for industrial relations models in the member states and so on. So one would think that the European Union balances this challenge by a strong social dimension to maintain our, going back is here, right? Yep, our interaction. But this isn't the case. The EU social and labor rights and EU social legislation was always weaker than the market regulation. We are not used normally to look at the member states. Is there market law in member states as well? Obviously, there is market law in member states, but it's much more conditioned and much more formed and, well, preordained by European Union law, especially when it comes to competition law and state aid law, but all the other areas of economic law. So does that make market law weak? So we can see even before EMU, the balance between economic and social integration on those several levels was pretty precarious and is still summarized with those criticism people, and I'm really sorry, I only cite men on this slide. Well, that needs to be revised. So European integration is fatally undermining national social compromises. Ferreira counters that with an optimistic idea. Well, actually, European integration is just a new phase in building, in European state building, and logically it restructures those national compromises, but he also sees a way of developing European compromise, which is challenged by Roderick, who says, well, the dilemma between economic integration, national sovereignty, and democracy is insolvable. Either you have economic integration and democracy at the same level as economic integration, and then you can have a level playing field between social values and economic integration, or you maintain national sovereignty and national democracy, but then national democratic scope for decision must be compromised by the economic integration project above. I don't buy in this, which you are not surprised to hear, and I think Jukka Snell, who's of course a lawyer, had a bit more positive view there and said, well, as long as we stay in the internal market, our varieties of capitalism, our different ways to organize socio-economic life can be accompanied. But he was quite doubtful whether this also happens in EMU. And that brings me to my next slide. How many minutes have I got? Oh, that's all right. 10 minutes for the first part. Big breath. So what this comes up to is that while there is a precarious balance, that precarious balance is already tilted to the detriment of the national level. And especially when it comes to organizing social solidarity only at national level, then the national level can still do that based on its national democracy, which is legitimate by input legitimacy and so on, but however, they are always subjected to constraints from the internal market. I think within the internal market we can solve this. So whether you think it's all an issue of national versus EU competences, whether you think it's an issue of whether it's the courts, including the Court of Justice, which should tell us the limits of social integration, or whether this is a matter for the legislator, or whether you think it's a mere tension between economic and social integration, you can address this conundrum when we stay just with the internal market, with guaranteeing economic freedoms, with guaranteeing competition law, with guaranteeing all those corner points of the economic integration. And we can balance this, I say, and that's a minority opinion, by giving the Charter of Fundamental Rights for the European Union its adequate weight. The Charter, of course, guarantees loads of rights. It also guarantees the rights for economic actors. And that's why it has a bad reputation in some social lawyers' circles at the moment. However, the Charter is based on the principle of human dignity. And if you look through all the rights of the Charter, I think there are 3 different categories. One category is unlimited. One category is limited by the treaties and by secondary law. Another category must be balanced through the other rights. And if you really evaluate very carefully, which I don't do in this talk, where social rights stand, where the rights to business activity stands, then you find that those latter rights are more limited than social rights. And that's how you can balance the internal market with social integration. And that hinges very much on the authority of judges. So I don't think that adjudication versus legislation is the right way of looking at this. It's adjudication complementing legislation. Now, if we move to the EMU, that is one of the things which is different. Economic and monetary union is obviously two fields. It's economic coordination of economic policy and monetary union. And the judicial branch of the European Union only has very limited authority in economic coordination. That still applies to the present day. So, and when it comes to EMU, how we can reconcile economic monetary union with maintaining social solidarity, with creating a European pillar of social rights, things are more difficult. And I think that is partly related to the original design faults of the economic and monetary union, which have been there since 1993, although they have been experienced more forcefully since 2008. And it has been reinforced by the reactions to the global economic crisis. But still, I'm not without hope, because that's just what I am. So the design faults, of course, of the introducing common currency, and here I can go a bit faster. If you think that the currency is normally a national thing, a national policy issue, then you also will try to locate so-called stabilizers, which allow national economies to react to a cyclical crisis at the national level. Now, if you introduce an EU common currency, then the national stabilizers are evaporated. So the national people, the nation states can no longer devalue their currencies, which in a crisis attracts investment, attracts economic activity instead, and in the crisis then it would also increase demand. Instead they have to go to internal devaluation for lowering wages, lowering social benefits, which then constricts demands, which weakens the economy. And so that is what introducing common currency does. Now, does the economic and monetary union give back the same steering potential at the European level? Well, is it true that we don't have any quantitative easing by the European Central Bank? That's not true. Yeah? So in practice, the European Central Bank has engaged in some quantitative easing. Is it true that we do not have redistribution mechanisms which would redistribute funds from more affluent member states to the other member states? We've just learned we can't have this because of moral hazard, right? So moral hazard is obviously something which governs our economic and monetary union, and actually the treaty somehow gives a few limits to redistribution mechanisms. Our national banks have lost in the Eurozone the opportunity to be lenders of last resort, and the European Central Bank, is it a lender of last resort? I think that's disputed. I won't meddle with this dispute here. Yeah, so there are a few holes in the functions of the economic community. Of course, when EMU was introduced, the Delors plan made us believe that we could achieve still maintaining the distinctive common feature of economic systems in Europe, which is a combination of freedom of the market with social services and public goods. However, there's a profound criticism whether this these aims were realistic. And I summarize these on this slide. So the political economy critique of economic and monetary union can be summarized by contrasting what a currency should do and what economic and monetary union does. A currency should somehow aim at providing adequate resource allocation, because what a currency is, it enables us to trade, it enables us to trade different areas. It enables us, if you go back to Durkheim, we could even say a currency is about not mechanic, but about organic solidarity. And if optimal resource allocation happens, then we have stable economies, we have the adequate income for all aspects for all partitions of the population, which also means we have adequate demand from internal, but also internal demand, which then control inflation. Some of the German orthodoxies will say, well, this won't control inflation, it will spiral inflation. I leave that out, but that's ideal. So economic and monetary union does it differently. It says resource allocation is a matter for the markets, not a matter for the currency. A strong market belief underlying economic and monetary union. However, the union needs to guarantee stability of public budgets, and it needs to control inflation. However, there's no engagement with adequate income or with combating unemployment, and that then has a potential negative effect on demand. So that's a summary of a very popular critique. I don't buy the critique with the optimal currency area. We can go that in the discussion if you like, because if you look at any country, it's not an optimal currency area. Okay, so that's where we were in 1993. Yeah? So things weren't good. And this was, of course, exposed with the crisis, and I haven't got the kaboom picture, which some of the economists often like in the crisis. I just go directly to the reactions to the crisis, new economic governance. And how am I on time? I'm fine. So, as a reaction to the fallout of the global economic crisis, starting with non-regulated banking sectors, not in Europe, but partly also unstable sectors in Europe, the European Union obviously has tightened the governance of European Union. I think new economic governance is still a very profound euphemism, because new governance was supposed to be governance by cooperation between societies and economic actors and the local actors. In new economic governance, on the one hand, new governance comes into its own because it was a Maastricht Treaty which first introduced coordination in the economic field, long before it became new governance in the social policy field. And it also became a way of trying to control or to tighten the coordination of the member states' economies, although the EU continues to lack the force of law in coordinating the economies. And so this happened, as we all know, through the European semester, which tightens the control of budget discipline and the stability of public debts, stability of public budgets. The Treaty of Stability, Coordination, Governance introduced some constitutionalization of those budget discipline and public debts in the Euro member states. And then in cases where states still do need external help in order to serve their sovereign debts or to remain floatile on the international monetary and money markets, the European Stability Mechanism, which is the last emanation of a series of interactions, promotes the idea of tough love. So states can only gain support, solidarity, in the words of the former speaker, if they promise to maintain budget discipline and public debts, and in accordance to the, should I say ideology? I'm saying ideology. Accompanying all this means retrenchments of the welfare state. This means also structural reforms. That's a euphemism, which means retrenchment of welfare states, which means changing of labor laws, as Spain knows so very well. So all these new economic governance then leads to a dynamic which arguably challenges those European values which have been stated in by the former speaker, and which I have also had on my former slide. So, social justice. I personally think that solidarity, although it's mentioned, solidarity common to the society in singular in the member states in Article 2 of the EU Treaty, I still think it's a value of the EU, but we can discuss that, because you said it's not, and so it's an interesting theme to discuss. And in summary, the new economic governance leads to challenging those values. What is more interesting, perhaps, is that this whole new economic governance also contradicts the idea of harmonizing the living and working conditions with an upward trajectory. Because all these programs, all these recommendations, CSRs, yeah, so always oblige member states to bring their house into order, to stay within the national frame, and to differentiate. Member states which already operate a system, and I understand that varieties of capitalisms are nowadays called growth models. It's a term which I use with reluctance because I don't think economies can grow. But so member states which rely on exports for their growth models will have different ways to address their CSRs, to react to the European economic semesters, the member states whose economies or growth models are based on consumption. Yeah? And that is, Hall, for example, makes this point in different impacts on different varieties of capitalisms by new economic governance, says, well, new economic governance leads to differentiation. It needs to disintegration of Europe, and this is one of its aims. Those member states which are more in need of adapting and structural reforms need to develop differently from the ones which are strong. So, and that's what I find is the main issue. Europe abandons the idea of progressive harmonization. Now, can we get out of this EU conundrum with a macroeconomic criticism of EMU at large, with a social science debate on whether our new governance is effective, whether the perception of the operation of the EMU is perhaps even one of the triggers of new populism, new right-wing populism, in addition to the refugee crisis, and our legal scholars who sometimes cling to the values versus EMU constitutionalization, or on the other hand, who say, well, the law can't fix it all. We need some background, and we are not responsible. So there are obvious limits of the law. Is there any solution? So my solution is very tentative. So obviously the European Commission thinks that the European Pillar of Social Rights can be a solution. It was introduced originally with the aim of introducing a social soul into economic and monetary union, and as since now, as it has been proclaimed, applies to the whole of the EU. The European Pillar of Social Rights, I think, is quite contradictory. On the one hand, it conjures a promise of rights. Yeah? So European Union citizenship should mean something. We do have rights, and quite a big variety of them, even if the pillar only confirms all those social rights which have already been addressed by legislation, it still would achieve something. The problem is that the European Pillar of Social Rights remains at the level of a policy program, and at the same time of raising all these promises, it has an inbuilt disappointment that perhaps you cannot really rely on those social rights. And that's why I think that, and I think this is also what the authors of the Pillar of Social Rights, part of them, wanted, that we need to go further. We need to create European-level solidarity institutions. Now, this is not really easy. There has been a lot of debate on macroeconomic stabilizers, and one of the macroeconomic stabilizers which has been debated is European unemployment insurance. And of course, Many people in the room will share the legal assessment that we can't have a European unemployment insurance on the basis of the current treaties. I think what we can have is an insurance which addresses a specific risk of free movers to become unemployed that can be based on the free movement of workers chapter, but this is not the economic stabilizer which was desired to be an unemployment insurance. So, however, if the member states, in all their diversity, which is enhanced and reinforced by the governance of economic and monetary union, are further and further differentiating, that means that a number of member states no longer are able to address the social risks. And that means that there needs to be some transnational institution building. So the case study we are doing in the other paper, so I'm not going, possibly not writing about long-term care in that chapter, let's see, is long-term care. It's one of the most pronounced future social risks. We all are getting elder, and we are not dying early enough for not needing care, and that's why the societies run into a care crisis. The lack of affordable care institutions results either in deprivation of those needing care, or may force their female relatives out of employment, or may force their families to ruin themselves by paying for that care. Member states' efforts, some member states have made efforts to create institutions, for example, the new branches of social insurance. And if member states were to do this, this may result in expansion of public budgets, which again may run them into difficulties with the Stability and Growth Pact. And there are examples of the interaction of new economic governance and long-term care provisions. In Spain, for example, the long-term care sector has been negatively impacted by austerity measures, and that's not even a country which was in official need of ESM help, so it was just avoided. Even in a country such as the Netherlands, where no crisis regime applied, they were partly under a specific regime. The Netherlands found themselves consistently subjected to a specific recommendation to reduce public spending in the long-term care sector from 2011 to 2015. And after 2015, the CSRs, the country-specific recommendations, none of them said anything about the long-term care sector any longer. So there is a risk. What can be done? Well, creating long-term care insurance at EU level, that would be the same problem as for unemployment insurance, a competence, and I've listed the treaty provision here, Article 153 TFEU. And in social security, only coordination in limited cases, harmonization is allowed, and none of that can create EU-level institutions. So in our common paper, we probably air the idea of allowing cooperation of member states through European groupings of territorial cooperation that requires legislation by the EU. Presently, such legislation only exists for other areas, and that could be done for social security, I think. Of course, one needs to overcome the hurdle of Article 153 and not creating a contradiction. So that could be one solution. Now, I haven't got a conclusion slide here, because as I said, this is an experimental presentation. I still would like to summarize what I've said. I've tried to say that there is that if the EU wants to regain their legitimacy, it needs to address a social deficit which is experienced by its citizens, especially in the wake of the global economic crisis, and that is a second trigger for Eurosceptic voices, which are also right-wing populism. The EU can realign the internal market and social justice, social solidarity, and so on. That can happen through the reinterpretation of economic freedoms and competition law. It is much more difficult to realign economic and monetary union and social solidarity, because as we heard in the last presentation, the economic and monetary union is based on the principle of limited solidarity. To address that, short of treaty change, I'm not sure we get any good treaty change in reforming economic and monetary union. To address that, flexibility and creativity is needed. And I think one part of the flexibility has already been shown by the European Union by adopting the European Pillar of Social Rights. However, it's a very non-binding present at the moment. Oh, I've already stolen a minute of you, sorry. And that's one thing. Secondly, Europe needs to go further. It needs to realize the creation of social institutions at European level, and this is going to be very difficult, and we are trying to air the idea of European grouping of territory cooperation, which possibly will remain a minority opinion as well. Happy to hear criticism to make that model better. Thank you very much, and I've seen that some people have photographed the slide. I'm sure the slides can be made available, especially as I have also some references on the last slides. Thank you for your attention.
So, thank you so much, Professor, for this wonderful and thought-provoking explanation. So I think we have many things already, and we have identified some differences between the speakers, so it will foster discussion later. And now, please, Professor Kilpatrick, which is going to talk about the EU fundamental rights gap. Why did the EU sovereign debt programs massively breach international human rights but not EU fundamental rights? So please, Professor.
Can we just swap?
Yes.
I need to get out of the slides.
Yes, sure.
Can
Yes.
we find the slides?
Okay, so,
There.
how are we moving about?
I'll just swap with Martha.
Okay, well, that's very good. So I can get to my own bag, and you can get to your bag, and she's welcome to myself.
Perfect, thank you. Hold on, I'm just going to take this with me. So first of all, thank you very much for inviting me. I'm already having a lovely time, and it's a pleasure to be back in Barcelona. So first of all, this is still a paper that I'm thinking about and working on, so I've already presented versions of it. I think Paul has heard it now, so he's probably got very good arguments against my paper by now. But until I finally finalize something, I keep presenting it and thinking about it, and that's where I'm at with this paper. So this is what I want to explore today, why the sovereign debt program has massively breached international human rights, but not EU fundamental rights. So nothing to do with the European pillar. I'm really focusing just on this. So I'm very much focusing on the 10 EU states that had a program status or related to a program status over the last decade. So that is the 3 non-Euro states that were in programs, that went into programs first under the balance of payments assistance, so Hungary, Romania, Latvia. Then the 4 Euro states that were in full programs, that is Greece, Ireland, Cyprus, and Portugal. And finally, also I included the 2 states that had some kind of hybrid status. So Spain, which did have a large sovereign debt program, but only applying to the financial sector. So the IMF was therefore not involved in that program. And Spain and Italy also because they were subject to European Central Bank bond purchase conditionality under the Securities Market Programme in the summer of 2011. And there's been some interesting work done, especially on the Italian ECB conditionality, charting how that actually did function as a genuine conditionality, at least in the case of Italy. So those are the countries I'm interested in, and we all know many of us personally lived through these programs, or their families lived through these programs, so we know quite a lot about these programs. And I was particularly interested in them because the conditionality that accompanied the programs in the famous MOUs often involved an extensive dismantling of labour and social rights and institutions. And so what I'm interested in today then is how come those programs massively breached international human rights but not EU fundamental rights? So what explains this difference? So the first thing I need to do, and which I'll try and do relatively quickly, is to show that they did massively breach international human rights. So I do that. I've done a good bit of work on this, but today I'm going to look just at two rights systems. First, the UN system of human rights treaties. So you see here, these are the six human rights conventions that are mainly affected by the sovereign debt program. So I don't think, and thank God, the Convention Against Torture was centrally related to sovereign debt, but these six of the 9 main human rights treaties, these six were potentially affected by the sovereign debt programs. So here they are, and you know how it works. Each has a committee. There's periodic reporting, and also most of them have various protocols that allow individual complaints and so on. But what I did was I just looked at the monitoring systems during the crisis period to see when the committees found human rights issues, concerns, recommendations, and so on in the sovereign debt states. So here you see, so I have, you see each committee has its little acronym, and then you can see anytime there's a yellow or a green, that tells you that that committee was concerned and issued expressions of concern in relation to that particular member state in that year. So you can see this is a very substantial finding, and these are those findings that are directly related to the sovereign debt crisis, so that explicitly refer to the sovereign debt crisis in the concerns or recommendations issued by the committee. So I just put this all up here to give you a sense, a wide-ranging sense of how many human rights concerns the sovereign debt programs raised in the UN Human Rights Treaty bodies. And just to give you a sense of what this means, you know, so it's all very nice having all these figures, but what do they actually mean? So I'll just give you an example from Greece in 2015. This is the Committee on Economic, Social and Cultural Rights, which you'll see in that year issued 4 expressions of concern in relation to Greece and 4 recommendations. So I'll just give you the examples of the recommendations. So the first one I've given there is about Social Security. So these are the concerns. The austerity measures have led to drastic cuts in Social Security benefits. Current coverage is inadequate to ensure decent living, and so on. And then also the healthcare system, which Dagmar also talked about in her presentation, so that's a nice link. Decrease in health expenditure, critical understaffing of the health system, and how that affects particular vulnerable groups, asylum seekers, and undocumented migrants who are particularly hard hit by the effect of the sovereign debt measures on the Greek healthcare system. So you see, this is then my evidence that the sovereign debt measures did provoke a very wide-ranging, across all the human rights committees, the 6 human rights committees that I've mentioned, finding a massive breach across the human rights treaties. Then, more evidence, turning to the Council of Europe system, I looked at the European Social Charter. All the EU sovereign debt states, all 10, have ratified the 1996 Charter. You know, then we get into which charter and which menu, and the Social Charter is a complex source. Only Greece has not ratified the 1996 Charter until very recently, so it was dealing with the 1961 European Social Charter. And you also know there's a collective complaints procedure under the European Social Charter whereby you can take collective complaints, and this has been, not all states, EU states have ratified that, but Greece has, and in fact this was an exceptionally rich avenue. The Greek unions and pensioner organisations fully embraced the possibility to take collective complaints to the European Social Charter, and you can see here we have 10 complaints, all dealing with the sovereign debt measures before the European Committee of Social Rights. So this has produced then a very rich and interesting jurisprudence on the sovereign debt measures and their compatibility with the social rights in the European Social Charter. So let me give you, these are the breaches, or outlining some of the main breaches found by the European Committee of Social Rights. So no notice in the first 12 months of employment, for example, is a breach of the right in the European Social Charter to a right to a reasonable period of notice. And perhaps most strikingly, the committee made very strong decisions about the radical measure to exclude young workers in Greece from essentially all labour and social protection. So that breached a wide range of ESC provisions, the right to 3 weeks paid holiday, the right to vocational training, and the 32% cut in the minimum wage for under 25s, which placed young Greeks below the poverty line, was found to be a breach of Article 4, Paragraph 1, the right to a fair remuneration, as well as the right not to be discriminated against as a young worker. So here we go. You see, there's a lot. So this is then to say massive breaches of human rights were found by the European Social Charter in the sovereign debt programs, and these are specific examples from Greece. And I just want to then, you can see that these cases have been going on from the beginning of the crisis, because the Greek unions and pension organisations turned very quickly to the European Social Charter collective complaints procedure. So we have also the unions going back again, saying nothing's changed, things are getting worse as the programs continued. And this led the committee to make a particularly striking set of statements about the violations. So these are statements you don't normally find in the findings of the European Committee. So the violations are particularly serious due to the large number of provisions concerned and their effects, the number of victims affecting a significant part of the population, and the persistent nature of some of these violations already identified in the examination of previous complaints. And the committee goes on to say, these violations do not simply concern the Greek persons protected, they also pose a challenge to the interests of the wider community and to the shared fundamental standards of all the Council of Europe's member states, namely those of human rights, democracy, and the rule of law. And there's actually, I mean, one can say much more about the European Social Charter system. So one has the Greek government going before the committee saying, we don't want to do this. We don't want to breach the social charter, but we're being forced to. And the Commission, the European Commission, going along saying, well, this just has to be done. So you get these very odd and I think interesting juxtapositions, which I think are very interesting for those interested in the EU's role in protecting human rights. So I hope then that that is sufficient evidence of massive breaches of human rights in the sovereign debt programs. But there is a counterexample and in the field of human rights, and that is the European Court of Human Rights, which also received quite a few challenges, and it took a different approach. So it's the exception in the human rights landscape. So here I've given a few examples, one from Greece concerning a pay cut, one from Portugal on the pension cut, and then the Greek bonds haircut of 2012, which was challenged by those who suffered losses as a result of the private sector involvement in the second Greek program. And you see that the approach taken by the, so how come the European Court of Human Rights does not find that any of these things are a breach of the right to property in the European Convention of Human Rights? Well, the reasoning is the same in all the cases. Very wide margin of appreciation available at national level in implementing social and economic policies. And then they check, is there any special or excessive burden on the individual involved in these cases? And in each case, they say no, because in the Portuguese case, for example, the person lost just under 3,000 euros of pension over 2 years, which, I mean, not nothing in my view, but according to the Court of Human Rights, that was a temporary and one-off loss, and so on. So that is the exception, though, and that's important when we go on to look at or consider why then has the European Court of Justice, despite its new shiny EU Charter of Fundamental Rights, never found any sovereign debt measure to breach. I keep thinking I'm going to have to update this paper because they're going to find a breach at some point, but so far, none. So why then? Doesn't it seem odd that all these breaches have been found by all these international human rights bodies, but never has the Court of Justice found any sovereign debt measure to breach any of the rights in the EU Charter of Fundamental Rights? So that's the question for contemplation and discussion. Why not? So here are then some possible explanations, but there may well be others. So not enough cases or no cases. That's a first possibility. Second is that the sources, the legal sources or the judicial procedures before the Court of Justice blocked the cases somehow or other. Another hypothesis is that the challenges that were brought were different, or the rights are different. Another is that courts and human rights bodies operate differently. And final hypothesis is the dominance of the Strasbourg Court as a source for the Court of Justice, so it simply doesn't see the massive breach of human rights. So I think these are all worth considering, apart from the first. So these are the challenges to the sovereign debt measures before the Court of Justice, or the main ones. I mean, others have been joined to other cases and so on. So I think this gives but anyway, it certainly tells us the Court of Justice, the General Court and the Court of Justice had many opportunities to decide on the fundamental rights compatibility of the sovereign debt measures. So that then means we need to move on. So that is a very bad hypothesis. That's not right. So what then about blockages in legal procedure or judicial procedure before the Court of Justice? So this is certainly part of the explanation. So the first 6 cases that you see there in the preliminary references from Romania and Portugal, so these were all preliminary references, whereas the Euro area agreement programs were only challenged in annulment actions and actions to damages. So the first 6 cases here then were the first 6 preliminary references from Romania and Portugal were all rejected kind of immediately by the Court of Justice. just an order, no Advocate General's opinion. It said, as the referring courts didn't provide any evidence that the contested sovereign debt measures implemented EU law as required under Article 51, paragraph 1 of the Charter, the court had no competence to decide the reference. So, you know, one can say, well, maybe they could have helped the national courts a little bit. The national courts were completely lost with these MOUs and so on. They couldn't work out what sort of sources they were, and they were not on their own, because if you read the Advocate General's opinions in all the more recent cases, they are also completely lost. They all disagree with each other on what these MOUs are. But in any event, in the peak crisis period, these first 6 cases were just rejected out of hand by the Court of Justice, because the National Court did not say, here is the implementing decision under the balance of payments under Article 143, it links to the MOU, so the court just threw all the cases out. Then we have annulment actions. So ADD and LEDRA. These were taken by 2 different groups who felt that the programs affected them negatively, unions and their members on the one hand, and bank depositors or shareholders whose savings or shares were taken to recapitalize Cypriot banks in the Cyprus program of 2013. How did they fail? Because here the answer is not how did they win, it's always how did they fail? They failed because in ADD, the litigants failed to show they were directly concerned by the excessive deficit decision, which was addressed to Greece, not to those individuals, and Greece had discretion, so-called discretion, in implementing the measures, therefore no direct concern. Or because the Court of Justice in Ledra and Malice, so the Cypriot depositors, failed to find an EU legal act. The EU did not act because authorship could only be attributed to the European Stability Mechanism, which was an inter se member state agreement and not an act of the EU. So all the annulment actions failed for those 2 reasons: no EU legal act or no direct concern where an EU legal act was identified. Actions for damages also failed. Now, much has been made of the fact that in Ledra, the Grand Chamber in 2016 took its first step, I mean, still important, to linking the EU with the Euro area programme, so it found that an action for damages could be taken by the depositors against the Commission on the basis that the Commission, as the guardian of the EU treaties, is required under EU law not to sign an MOU whose consistency with EU law it doubts. So at the moment of signing, but also in the most recent case, Christostomides, also during the implementation of the programme, there is an ongoing obligation to check consistency with EU law. But you need to embed that finding within the action for damages. And this is all, you will, those of you who have had to teach this ever will know, oh my God. Anyway, so where did they fall? The applicants felt the need to show a breach of a rule of law intended to confer rights upon the individual. So this is one of the elements of the action for damages. No rule of law breached here, because any restriction on the depositor's property rights was justified by the need to ensure the stability of the euro area banking system and to prevent spillover to other sectors of the economy. Just to give you an example more in relation to social rights of an action for damages, which shows how difficult it is to get to the end of an action for damages. So the action for damages is a bit like the highly successful no-deal Brexit, in my view. Something you dream of, but is actually not going to turn out like that. So Sotodopoulou was an action for damages in relation to Greek pension cuts. So the Greek pensioners claimed just under €1 million of damages for a breach of the right to dignity in the Charter, the right under Article 25 for the elderly to lead a life of dignity and independence, and under Article 34, the right to social security and assistance in the EU Charter. They took the action against, again, the excessive deficit decision addressed to Greece. This failed because of another element of the action for damages, the need for the EU to have committed a sufficiently serious breach by manifestly and gravely disregarding the limits of its discretion. General Court found, because of the terrible meltdown in Greece and its implications for euro area stability, it was not manifestly unjustified to cut pensions, and the Council had not disregarded the limits of its discretion. So, these are then how legal source blockages and judicial procedure blockages, so the elements that you need to satisfy to win various challenges before the Court of Justice, meant that these cases failed. What about the fact that there are maybe different rights involved here, that the EU Charter of Fundamental Rights is not like other human rights sources? So very few of these challenges, for the reasons we've seen, got through what we might be able to call some kind of substantive fundamental rights determination, but some did. We saw that in Ledra, the court found the restriction on the depositor's property rights was justified, and the recent General Court decision in the Chrysostomides takes a similar approach. In Florescu, judges had their pensions taken away if they were still working at the university, and they were paid enough. They claimed this breached the right to property. This was rejected by the court. The cuts served the general interest. Anyway, no breach, because the individuals could resolve the situation by just stopping work and receiving their pension. So, in Soteropoulou, the Greek pension cuts, the court said, if we had to consider the substance of Article 34 of the Charter, the right to social assistance, social security, there would have been no breach. These aren't absolute rights, rightly restricted to pursue objectives of the public interest in Greece and the euro area. And the Portuguese judge's case, which has become a very famous case because of it's called the Portuguese judge's case, but it should have been called the Polish judge's cases because it didn't help the Portuguese judges, but it hopefully might help the Polish judges. In that case, pay cuts were found not to breach the principle of judicial independence. Why? Because those pay cuts were not specifically addressed to judges, but to a wide range of public officials in Portugal as part of the Portuguese program. So part of the explanation then might be the challenges are very different to those which were successful before human rights bodies, but quite close to those which failed. So the right to property was a central feature of the Court of Justice challenges, but was also the property, the right that most often failed before other human rights bodies. But I think we should be wary of saying, well, these cases are just like the cases before the Strasbourg Court. They're property rights cases, so it's just kind of the same. I think that first, we should not equate decisions coming via preliminary references or actions for damages, which concern legality of measures under EU law and also the effects on the people, rather than the victim-focused manner in which the Strasbourg system works. And of course, unlike Strasbourg, the Court of Justice is interpreting a charter which is supposed to have mixed civil, political, and social rights. So it should approach these cases then in a different fashion. But even if we look at the cases, not the property rights cases, but the more social rights focused cases, many of which got stopped by the Court of Justice very early on, but which concerned social rights in the Charter, I think another sticking point is it's not very easy to see which social rights provisions of the Charter one could sustain persuasively have beyond any doubt been infringed. That is to say, the social rights in the Charter, EU Charter, are less strong and comprehensive than they might first appear. And the sovereign debt episode allows us to test that and demonstrate it. So let's take some of the key issues raised by the Greek cases before the European Committee of Social Rights. Cuts to minimum wages across the board or for young people. That could not be challenged under the EU Charter of Fundamental Rights as a breach of a right to fair remuneration, because there is no such right in the EU Charter of Fundamental Rights. Instead, you would have to base a challenge on Article 31 of the EU Charter, which says every worker has the right to work in conditions which respect his or her health, safety, and dignity. That is much less precise a basis for making a challenge. Or take the finding against Greece on the right to a reasonable period of notice. So Greece got rid of any notice right for the first 12 months of employment. This was found to be a breach because the European Committee of Social Rights has a very clear, long, elaborated jurisprudence that you need no less than 1 month's notice after 1 year of service. Instead, the Court of Justice would have to decide, does this breach Article 30 of the EU Charter, which says every worker has the right to protection against unjustified dismissal in accordance with union and national law and practice. These are much less robust and targeted footings for successful challenges, in my view. And no less importantly, perhaps most importantly, the provisions of the European Social Charter and the UN Human Rights Treaty bodies have been the subject of a long and rich process of elaboration and elucidation via periodic reporting from each state, conclusions, collective complaints. And to my mind, this really makes a difference. The fact that the EU Charter of Fundamental Rights is only the focus of judicial interpretation is, in that sense, a weakness and not a strength. Another possible explanation is that courts are different from human rights bodies. So here I have a little quote. Here you go. It's not. This is some people making exactly that point. So focusing on Economic Social Committee, the UN Economic and Social Rights Committee, they say, well, they make general comments, concluding observations. These are limited to consideration of systemic issues at a certain level of abstraction. They rarely grapple with socio-economic rights at the level of individual disputes, controversies, or cases. So that's the systemic objection. And then a related objection. It's really easy to be firm and find a breach when your decisions are non-binding. So that is the, so these are, how convincing then are these explanations? Well, these are both related to the UN system, and I think that the European Social Charter is then a good counterexample that would require one to say, is it really true? Because those were assertions of breaches based on specific disputes. The collective complaints procedure is precisely about specifying disputes and making specific findings of breach. A further counter-argument to this distinction between courts and human rights bodies comes from the example of several national constitutional courts, not the one from Madrid, but in Riga, Bucharest, Lisbon. We have incredibly interesting jurisprudence of those courts striking down sovereign debt measures because they breached national constitutional rights. Still, we still might think the binding nature of decisions by European courts and the non-binding nature of human rights bodies might be a factor affecting review, and therefore still worth thinking about that. And the last one I suggested as a way of explaining why the Court of Justice had never found any breach is the dominance of the Strasbourg Court for the Court of Justice as an external human rights source. And indeed, we have seen in Florescu and the other cases where the court does engage in review, where it gets that far, its review is rather similarly structured to the European Court of Human Rights style of review. In addition, the ECJ only ever acknowledges or uses European Court of Human Rights jurisprudence as an external human rights source in these judgments. So, for example, in Florescu, you see the Portuguese judges, not the judges case, the pay cuts for the university professors. The Court of Justice drew very extensively on European Court of Human Rights jurisprudence to ground its finding that the right to property had not been breached. So my conclusion here, so I think this is good because Dagmar makes the strong case for the Court of Justice being the place to go for enforcing EU Charter of Fundamental Rights, but in a different context. But this particular example, these cases, this case study suggests the Court of Justice has been a weak human rights court, especially when it comes to social rights. And I have given a number of possible reasons for that. The Charter is a social rights document, and that social rights have a much weaker basis in the Strasbourg Court, which is the Court of Justice's primary referent. But also we might suggest the Court of Justice was determined not to address fundamental rights issues while programs were at their height. So it had a political interest in delaying access to the Court of Justice as long as possible until the programs were over. So these factors then might help explain the EU rights gap in the sovereign debt programs. But I think instead of sort of saying, well, that's fine, now we understand what's going on, I think it opens a set of really important and challenging questions about the EU as a legal order and how it interacts with international human rights institutions when they find that norms directly connected to EU norms and institutions are in violation of the rights they protect. So this is a very wide-ranging example, but there are other examples in the social rights area. Posted workers has also provided an area of conflict between the EU and international human rights bodies. And of course, the migration and asylum crisis creates another area where these tensions between EU actions and international human rights bodies' findings are of interest. So I think it's interesting to think what we might do about that or how to reflect on it. And I'm sorry, I've spoken for too long. Thank you very much.
Okay, thank you, Professor, for this provocative explanation, and that is really interesting to see how the ECJ reacts to these different phenomena. So it's time for discussion now. We have around an hour before we go to have lunch. So we've heard three different approaches, three different explanations, and very nice conferences about from one hand, the importance of solidarity and the limits of law to foster this solidarity, which is very important for the future of the EU institutions. The need of legitimacy, the need for legitimacy in the EU, which was addressed by Professor Schiek. And this final, let's say, deep analysis of the behavior of the EU institutions, in particular the ECJ, regarding the protection of social rights at the judicial level. So we are open to questions now, so you can ask. Yes, please.
Regarding the last explanation of the professor, I would like to know your position regarding the last point remarked by the Professor Sommermann of the role of the judges and the court to materialize the solidarity principle, and if you think that the courts are called to fix the social gaps in the economic issues, or do you think that courts have an active role and are the main institution called to fix and to guarantee the social rights, taking into consideration that it goes beyond their own control and depends on other factors of economic and politics. And I want to know your position about the active role of the court, if they have the key to guarantee the social rights, or otherwise they depend on other factors, and who's called to materialize the solidarity principle in the European Union.
So yeah, the role of the Court of Justice, I mean, I'm sure also others may want to come in, but I think that there has to be, I think the Court of Justice has shown a high level of variability, so in a sort of interesting way in terms of how it protects fundamental social rights. So on the one hand, one has quite strong protection, I would say, in certain areas. So in relation to status discrimination, the court has used the Charter in some really interesting ways. So one cannot just say the Court of Justice is terrible or doesn't believe in fundamental. That is obviously not true. And what's interesting is to get all these different strands and think what seems to explain the different approaches, the varied approaches the Court of Justice has taken in different areas. So that's one line of kind of investigation. So we also see recently, in relation to the right to annual paid leave, the Court of Justice has again kind of taken a step forward and used the Charter in a sort of mangled type way. Also in the relation to the right to annual paid leave. But we know that those are the two sorts of social rights that the Court of Justice has always been most comfortable with. Once we get outside those areas, which I would say are relatively separate from internal market rights or sovereign debt rights, then we see the court is a much more problematic institution. So, for example, the Ajet case, the Ajet-Iraklis case, is a perfect illustration of how the court struggles with cases that raise at the same both internal market issues and EMU issues, and social rights are not well protected. Neither the acquis nor the Charter rights are well protected inside that kind of reasoning. So I think the court needs to play a role when the legislature or other EU institutions breach fundamental rights, because if it does not play that role, who will play that role? You know, this is one of the roles of a court, to look at what other institutions are doing and to say, here you have stepped over the line, as it did, for example, in Test Achat, where it used Article 21 of the Charter to invalidate part of a directive. However, I think that when it comes to issues that raise strong internal market or EMU issues, we are probably better not relying solely on the court. So, for instance, the previous episode of social rights being put under pressure, the Laval episode, which was then overtaken by much bigger social rights issues in the sovereign debt crisis in terms of scale, that issue has been resolved by the legislature. And then now I think the court will listen to the legislature. So I think we need the court to play a role, but we should not solely rely on the court to sort out social rights tensions in the internal market or in EMU.
Add something. I have a overall more positive approach to the European Court of Justice. I think the main problem is that the court is not competent to judge on...
This is the positive.
No. I want to say that it's not the court who renounces to protect social rights, but we have a very low degree of integration in social policy. That's why now with President Macron and others want to strengthen this branch. It's a matter of applicability of these social rights of the European Charter of Fundamental Rights. Article 51 of the Charter, Article 51, only says that these social rights are applicable in EU legislation matters, if I may abbreviate it. But the social policy, the cutting of pensions and all that is still a matter of domestic law. And that's why the court cannot pronounce itself on these matters. I think this has to be borne in mind. Of course, the court could perhaps in certain EU legislation pronounce itself on social matters, but all the other, the International Covenant on Economic, Social and Cultural Rights, the European Social Charter, all these are international instruments that oblige all member states. That means they will control the domestic social policy. The ECJ cannot do it. That's just the difference. And I would not say that the judges are to blame, that they are not enough dynamic in protecting social rights. I would be in favor with your proposal to strengthen the Charter. That means to make it applicable also to social policy of the member state. This would be a way to bring in the European Court of Justice. I think this is the only way. Or another way would be to strengthen the competences of the EU in social policy. I think you said the economic and financial aspect should be strengthened by putting it in a complementary situation with the social policy. If this would be possible, and if the Union could adopt secondary legislation on social policy, then also the ECJ would come in. But until this is not the case, the court just cannot.
Just to chip in here, I think the role of the Court of Justice is very different in internal market areas and in EMU. So, and even in the internal market areas, I didn't say that the Court of Justice is all well and good. I think that in the internal market area, the jurisdiction of the Court of Justice can be developed in such ways that it doesn't contradict social rights protection all the way. And in these 2017 articles, which I cite as well, I make a critique of Heracles and say the court got it all wrong. However, the court could speak on this area and has spoken just in the wrong way. Yeah? And so I think they need to, and they could have interpreted the economic freedoms differently. They didn't have to go radical and say economic freedoms are for protecting business rights at national levels, and so on. So that's one area. In the area of economic and monetary union, I think that actually the court has naturally a much less pronounced role than it has an internal market, because there is so few legally binding coordination of economic policy isn't legally binding. Yeah? If the EU institutions make recommendations which are in violation of EU law, including social rights, then the Court of Justice must have the right to challenge that, and that's why the Ledra case was admissible. Yeah? Again, the judgment in substance can be criticized. Yeah, so, and I haven't written on that yet, so I'm still reserving judgment, so that's one thing. Then how does the Court of Justice get a better role? I think the way towards that is more EU legislation, that's right. Yeah? Because if there is no EU legislation, then we won't have a reason for the court to become active. And that's the last word on the Laval conundrum. I think the court has changed its way before the legislator spoke, because the Elektro-Budova case, which really is called by its Finnish name, which I can't pronounce, whatever thing, yeah. Elektro-Budova, I think it's very good. So the Polish counterparty. And that was a case which partly has been positivized by the new Posted Workers Directive. And that's a very good example how the legislator and the court cooperate, not always fully satisfactory from the field of social rights, but at least there has been some progress. So that's so far.
No, thanks very much. I fully agree with the analysis, but I'm wondering to what extent the last point raised by Claire about the context is not, well, to a certain extent more important than the actual matter of social rights. I think we can observe a reserve from the Court of Justice generally in those matters. If you look at quantitative easing, if you look at how the court has accepted ESM and other inter-se agreements, etc. So I don't know, I'm wondering if we're not giving too much importance to, you know, the social rights aspect rather than to the pressure that the court was undergoing at the time. And you said rightfully that the court tried to delay, you know, until the programs were over. So, yeah, isn't this another sign of this, well, competence creep that we observe in this area, and how member states and EU institutions accordingly have had to react with no safety net, so to say, in the treaties, be it about the Troika, etc. And then the court, well, could do nothing else but to accept what was going on. And the other question I have in this regard is whether there is not a general tendency by courts to be a bit more reluctant to strike down measures that have a high economic impact. So, I mean, that's, well, coming from ignorance, because this is not my area, but I'm under the impression that generally courts will not strike it down if it's going to cost a lot. And then I have a question for Karl-Peter, but maybe I get back to that later if the other... Okay. So the question regards this idea of solidarity that you raised and how this can be reconciled with growing diversity within the Union. And because I fully agree with you that the treaty is, well, mentions it, etc., but as an objective, but I also think, contrary to the European Commission, that we need to be, you know, looking at reality. And I think it's going to be increasingly difficult if you look both at the growing differentiation within the members or among the member states, and it's going to be more difficult if you have 6 Western Balkan states joining. So how do we reconcile this? And I'm wondering, you know, there is this idea of Macron and others to have different, well, concentrated circles within the Union, and do we then have different levels of solidarity among them? I don't know, I'm just throwing this on the table because I think it's a question that EU institutions are often reluctant to look at, and I think we need to consider them with 27 member states. Thank you.
This is for Claire. When you were talking about the influence of the Strasbourg Court, let me tell you that I was also working on property rights in a project in which also Catherine was. I was involved with economic rights, and looking at the cases that you have quoted, which may be helpful, I found that the Mamatas case, it was the court did not protect the property rights, but the case was declared admissible, and that is a property case, quite similar to Ledra. Whereas the other two, so that pension rights, they were declared admissible. So one of the ideas that I got is, see, this is more or less the same reasoning of the Luxembourg Court. Where property rights is close to social rights, then inadmissible. When property rights is more close to with traditional euthanasia property, then it does not protect, it was considered proportional, etc., but it was declared admissible. Yes, to highlight that maybe it's a good idea or not. And then I found very interesting when Professor Schiek said that the European Pillar of Social Rights could enhance mistrust, because there are many. I have seen. Was invited in Madrid to a conference and was a European Pillar of Social Rights, a new chance for social Europe. So I would like you to elaborate on that idea, because there's a lot of hope on the European Pillar of Social Rights, and perhaps that's the problem. I don't know. And just finally, when we talk about the recommendations, I have to say that I have struggled a lot with the fact that it is true that all these recommendations stemming from EU institutions in the frame of the EMU, yeah, they are recommendations, they are soft law, they are soft law that is a kind of hard law with this conditionality principle. And sometimes I wonder whether the point is not that the Court of Justice should elaborate a bit more on what soft law means. So I'm thinking about this opinion of Advocate Bobet on Commission versus value, and I think it was a very interesting case in which he said, go on to it or say it really doesn't matter at all, because it's not so clear. So I don't have the answer, I have to say, but I have struggled a lot. But I would say that perhaps part of the answer could be there, that the Court of Justice eventually goes more into what those recommendations actually legally mean, because the conditionality principle, they are not legally binding, but I wouldn't say they are at the same level as many other instruments of soft law.
First, Claire, you offer all those hypotheses to explain the role here of the Court of Justice, but you didn't seem much convinced, right, with those. And you offer, in the end, this explanation based more on the political approach of the court here. And actually, I just wanted to ask you about the extent to which the issue of the limited scope of application of the Charter, the Article 51, Paragraph 1, can also be another hypothesis to take into account, although maybe you, again, won't be much convinced, and that's actually what I wanted to ask you about, because we can, the question would be, to what extent we can always find a link even when the member states are implementing an MOU that is under the ESM, but would you argue for showing that in any case we can find that link and then make the Charter applicable, or that would be a real limit here? Because the Florescu case, we can say, was an easy case because the MOU was agreed, was clearly within the framework of EU law. But the Association of Portuguese Judges case, that, I don't know, we can discuss about that. The court actually didn't answer that question because it chose to go on the basis of Article 19, Paragraph 1 and the principle of judicial independence, but the Advocate General actually argued for the application of the Charter in that case, so I just wanted to know your opinion about that. Then for Dagmar, actually, I was thinking when you were talking before, that you focus on the issue of the new economic governance, we can wonder, I would ask you, to what extent there is also a new social governance in the EU. And then if we focus on that dimension as a consequence of, well, all the financial assistance conditionality and so on, so we can think that although the EU doesn't have the competences, it's actually ruling on those issues, and then the element of solidarity becomes very relevant, right, to the extent that the EU would have an impact on those issues without building on the solidarity at the transnational level yet. So you were actually offering as a solution to the EMU conundrum the European Pillar of Social Rights, right? And I was wondering, when before you were talking about the internal market conundrum, then the Charter was a solution for you, or a way to move forward in the protection of social rights there. So my question here would be, to what extent the Charter can still have some potential when we move to the EMU, or we shouldn't be thinking that can offer some sort of solution, and we need to move to the European social pillar. I understand that you would argue for a binding European social pillar, right? To the extent that it's not non-binding, I'm not sure how much of an answer that could be from your perspective. And finally, regarding the building of transnational solidarity in the EU, I was wondering, well, actually you were also very hesitant or even a skeptic about the law as a source for solidarity. So I guess the question would be then, what conditions or what elements would you think of that could help us in moving forward in terms of building solidarity at the transnational level?
Okay, I think you've got enough, but I have the privilege to be here with you, so I'll use my little power to formulate some questions to you. I'm sorry, but I think we've not time, and it's fine. So first, to Professor Kilpatrick, I was thinking, yes, Professor Sommermann is telling us that maybe the ECJ is not competent to address some questions, to some issues regarding the protection of social rights. But what do you think should be the role? You explained a little bit, but do you think that the ECJ may try to link some different treaties, some different to solve these blockages that you found, and try to link some the Charter of Fundamental Rights, the other instruments, in order to come up with solutions, or at least to solve these blockages that, or how could the ECJ do that, to solve these blockages through reinterpretations of the instruments we've had? Professor Sommermann, you told us that maybe the problem is that the ECJ is not competent to address these cases sometimes, but do you think that the principle of solidarity may be used by the ECJ to somehow, or the principle and the deep principle of social solidarity could be used by the ECJ to address some cases, let's say regarding the pension cuts or something like that? Could you say that the principle of social solidarity obliges states or oblige EU institutions to foster the increasing of living conditions to individuals, not just among states, as you told us? And finally, to Professor Schiek, Professor Kilpatrick told us about the cases in which constitutional courts addressed some instruments regarding the programs, the debt programs, and conclude that they were unconstitutional sometimes. Don't you think that this may be a good example of how national institutions, and in particular domestic courts, may help to reinterpret these economic liberties, as you have told us? You said the EU's legitimacy depends on the social polity, and we need to reinterpret the economic liberties through flexibility and creativity. And so do you think the domestic courts may play a role? Maybe if a domestic court concludes that something is unconstitutional and it goes before the EU institutions somehow, maybe they have at least to answer to those, to the position of the domestic courts, and they will try to address the reinterpretation they did at the national level, so they will have to reinterpret at the same time at the EU level. I don't know if you somehow. So that's it. Any other questions? So, no? Okay, so.
Let me start with the answering of the question, which is quite interesting. If the Court of Justice does not have competence to, let's say, decide on social cuts in the domestic sphere of the state arises out of Article 51 of the Charter. Are there other instruments? And you said, why not looking at the principle of solidarity? And indeed, in Article 2, among the values, we have a societal value of social solidarity. That means, could this be, let's say, a legal principle which could be controlled by the Court of Justice? I think it's a worthwhile reflection, but the result is quite difficult because in Article 2 you have very general values, and the question is if also considering the principle of enumerated competences in the EU, if you can, by just a very broad principle, let's say, find enough concrete criteria to control these social national policies. I would say in very evident cases, where really we have miserable situations of citizens, we might think about that. I think I would do this. I doubt if the court enters ever in this, because this is just one of the values, not very concrete. But I think in evident cases, I could imagine that you use this value for controlling national legislation. But this must be very evident cases. And the question here, if you look at Greece and other countries, the problem was that the governments were in a very bad situation to balance, on the one hand, the let's say requirements from the donators of money, and to regain a stable economy on the one hand, and on the other hand to maintain a certain social protection. Very bad situation. That's why I think the court, in your sense, is that you only can attack measures of the European Union that lead to internally to these social cuts. No? This would be my approach. And the other one, in very evident cases, I would think you can go to Article 2. Next point, Professor Torres. Source for transnational solidarity. You said I was very critical towards the legal approach, but skeptical. Yeah, I think this is true. But on the other hand, I showed like the principle of solidarity is transferred from a moral and social sphere into a normative sphere of law. And the approach had many effects. We have to admit that. The question is now, what can law do? The law can create an institutional framework that fosters the behavior of solidarity, not more. Yeah? It can create a legal framework. On the one hand, let's say hard obligations based in the principle of solidarity. But as I said, the difference between solidarity and the feeling, sentiment de solidarité, and the real solidarity is that in the legal sphere, we do not ask what does the single person think about it or feel about it. But there's a danger. If many people in a society start to think about it, no, I do not want to convey solidarity. I do not think that my state, my country should be solidary. Then we have a problem, a delegitimizing problem. That means that in a society which takes part in solidarity systems, we have to care for the participation of everybody in the long run, not of each single person, but of a great majority which is in favor of this solidary behavior. And this is a bit the problem we have in the time being. So law can contribute, and in transnational solidarity, you all know when something happens nowadays in the Far East or in Africa anywhere. We see that if you, for example, collect money for a certain crisis, that many people nowadays, because we have pictures of these catastrophes and everything, feel solidarity with other people. But it's far more difficult, because solidarity in the beginning, and this was what Jean Monnet said, if you in your own sphere feel solidarity, that others help you and you help others, and you know these people's création d'une solidarité de fait is nearer. But you said transnational more in the European sense, I suppose.
Yes.
Yeah, between member states, no? And then we come in the same point to your question, what happens if we have so many member states which are very different, which have a diversity of cultures, and this diversity of cultures is not only the diversity of culture in art, in feelings, and music and so on, it's also diversity of administrative cultures, of political cultures, and so on. So, on the one hand, the treaties try to integrate diversity in the program as a basic value. But on the other hand, we have this tension. The more diversity you have, the more it becomes difficult to maintain this coherence and solidarity. The only way to do it is really to define oneself about fundamental values. And that's why the behavior of Poland, Hungary, and other states, look at Italy, maybe later on in France, in Germany, wherever you have these populist movements, where it is so dangerous, no? Because these fundamental values give you the coherence. And if you put them into question, the system becomes very unstable. We have still one point. If you do not only look at values, if you read the Memoir de Jean Monnet, he was not so idealistic in a way. He was more relying upon the personal economic interests. He said we have to pool the interests. And everybody see my economic interest is well considered in this institutional framework. There will develop an integration and even solidarity. But you see, we have both elements, economic, personal interests, and these values. And as long as the interests are well satisfied, the danger of eruption of the system is not so strong. Look at Poland and Hungary for the time being. About the values, I think you cannot have really fundamental discussion that this is the main point, but they have interests. They will not step out for the time being because they get at the moment, the solidarity exercised by European states gives certain advantages. And I take only Poland and Hungary, not because it's Poland and Hungary, it would be with any state. What is so interesting that in the United Kingdom, I think those who really calculated interests would say, oh, it's perhaps, but you can tell me better like it is. Does really the mere economic interest is decisive? I think in the United Kingdom we saw the effect that people said, we do not want to be dominated also by Brussels. That means here we have a counter-example that under certain circumstances, it's not the mere economic interest that really decides the case. So to sum up, common interests, common values. And as long as you put in these values diversity and at the same time homogeneous common values, it will work. But that's why we have, let's say, to strive for maintaining these common values. And let's see how it will work out.
No, just a follow-up question. As you were speaking, I fully agree with you, but I just wonder, in the moment in which you design a system like we have in the euro area, that in the end is more advantageous to certain states because of the form of their economy. So we're not in the Jean Monnet, trade of different goods and values and people anymore. We are in a common system that will give advantage to certain states and disadvantage to other states. So can we then still have solidarity if we don't accept that? Because I don't think in the political discourse this has been this has been instrumentalized in Greece, for instance, whereby it's been said that this was good for the German economy, just to put things, as a cliche. But, if there is the assumption that from the beginning member states do not trade on or do not start on an equal footing, can we then still have this sort of European solidarity, even despite this idea of values? I don't know, just follow-up thought.
Comes now to the diversity also from the economic standpoint. You do not only have the cultural differences, but economically, and this means that the conditions of life are very different, no? Or certain time you thought they were equal, but it was only because you could have these loans easily, and later on it was seen that these loans were built on not the corresponding economic force. I think we need a mechanism of compensation within the European Union. I think it's not, and the regional fund, look at that, the social fund, these are all first approaches to mitigate certain situations of economic need. And I think we have to see it. If you look at the federal states, in all states you have a system of compensation, financial compensation. I know that in Spain it's also a big subject. Catalonia says we are economically very strong, and what about this compensation to other regions? I do not want to mix in this debate, but I can tell you from the German side that we always had these discussions. For the time being, it's Bavaria and Hessen who are the strongest state, who give the most money in order to distribute, and they even lodged constitutional procedures before the court, no? Saying that their economic force and their sound policy is punished by the system. Then came a reform. Now they withdrew their constitutional procedures because we made a constitutional reform which covers a bit what, it's more or less the same, but now the distribution is more done by the federation. The Länder put in the money, and it's not so much seen what Bavaria and Hessen gives really. And so it goes now more about distribution by the federation, to say it in a very short form. So this is a persistent problem in federal state, and it would be very curious if it would not be a problem in the European Union, as long as it will develop to a kind of real union. So the compensation, the internal compensation in the EU to help states to develop, I think is an essential aspect of European solidarity. And this is the only way also to maintain really that people stick and countries stick to also to the values. So now we can discuss, was it done in a sufficient way, this solidarity? This is a discussion. And you will hear Greek persons, many Greek lost their jobs, lost nearly everything, he had to leave sometimes their houses. This is something very hard in how to identify the system which, from their point of view, imposes such a situation. Because many people think this is also fault of the European Union. They do not only see the negative aspects of their own government, who made false policy, but you're right. I think it's necessary, and people have to pay for this peace and unity. We need that.
Although I have a long list of questions, which I'm certainly will all look into when I elaborate the paper. So one question was, how do I see the role of the European Pillar of Social Rights? And I combined the answer with the role of the Charter of Fundamental Rights and EMU matters, because they both are related. So I personally think that the European Pillar of Social Rights is and should be a policy instrument. However, the terminology of rights somehow raises the expectation that there will be something you can rely on. And if that expectation is then disappointed and not fulfilled, then the European Pillar of Social Rights will not have any integrative value, but it will rather be lead to further disintegration, further disappointment with the European Union. And that's a problem. So I think that is also why I choose to combine that answer with the with the answer to the question, how do I see the Charter of Fundamental Rights and EMU matters? Of course, the Charter of Fundamental Rights remains relevant also for economic monetary union. There are parts of economic and monetary union, specifically monetary union, which are legally binding, and also that leads already over to the soft law relevance, but I put that separately. Also, when the European Union institutions act in the field of coordinating economic policy, they are still bound by the Charter of Fundamental Rights. Yeah, and so insofar as the Charter of Fundamental Rights does have enforceable social rights, and you mentioned Article 31, Claire, of course that's one of the problem childs in the Charter, yeah? Whether you can say it is actually legally enforceable or not, and to what extent it is legally enforceable. So, insofar as these charter rights are properly legally binding, the actions of the institutions, even if issuing CSRs, like country-specific recommendations, should be challengeable. Yeah, but I think this is pushing the Court of Justice case law and admissibility of claims quite a bit. Yeah, so I'm aware of that. And then the TFIU also has kind of soft law, yeah, so programmatic provisions, which are still relevant, even if they can't be challenged in court, and these are quite relevant for devising new economic governments. So somebody asked me whether I shouldn't talk about new economic and new social governance in recognition of the 2013 changes to the European semester, was that what the what the question went to? And of course you have a point. Yeah, so the new economic government is still called new economic governance, but in 2013, with the addition of social elements in the European social semester, this demand, which I actually have to talk about socio-economic models and not social and economic, has been fulfilled. So maybe I should talk about new socio-economic governance, but then I'll be much more strict, because then, and that would be a valuable turn for the paper. So thank you very much for that concern. So then I have the question on the role of soft law. I'm afraid I missed an important opinion of Advocate General Burbeck on this soft law thing. I'll have to check that up, and I didn't understand the case name either. So the CSRs and anything which comes about in new socio-economic governance, as we call it now, is of course soft law of a special quality. Because while it's not legally enforceable before the European Court of Justice, because it's not legally enforceable, other enforcement mechanisms are added. So member states will have to make non-interest-bearing deposits, they may have interest-bearing deposits, they may have to pay fines, and even if this is not going the way of judicial enforcement before the ECJ, such sanctions may be more efficient and more effective and make member states comply with their guidance. And that's, of course, while the CSRs formally are still soft law, they are soft law of a special quality. And that, of course, also raises the question, shouldn't the institutions have a heightened level of responsibility in issuing those not so soft law guidances? I need to think of better terminology, obviously. And that again links very much to the question, where do you see the role of CFREU? So to the combination of national courts, and I need to leave 5 minutes for Claire, so I'm speeding up and leaving some stuff out here. So, but I think you have a point. The role of national courts in EMU program matters is very important, and in the past the Court of Justice has often been felt motivated by national courts' challenges to change its own case law. However, in this field, there are a few problems to bring it before the Court of Justice. I think it's more the European institutions which may, the legislators and other institutions which may react to the national courts. So I skip Article 2 on solidarity. We leave that for dinner, yes, if that's all right, because otherwise Claire doesn't have any time to answer. And when we come to the diverse models in the member states and EMU, so so there was a question about whether EMU doesn't, if EMU doesn't have the same effect on all the economic models, isn't it more unjust than it was initially conceived? And I think actually there were some things which were overlooked when EMU was conceived. So one thing which was overlooked was the relevance of the role of private debts, which really differs in relation to the role of house ownership and other ways of getting access to housing in member states. That was totally overlooked and never considered. And then I also think the differences between export-oriented countries and more consumer-oriented countries or home consumption-oriented countries wasn't really conceived when EMU was devised. So I'm a bit hesitant of recommending redivision of EMU by way of treaty change, because I don't think we get a better treaty base at the moment. However, the EU institutions have been quite inventive with revising EMU short of treaty change in the past, and these two differences need to be considered in addressing in the future of new socio-economic governance much more than they were. So 5 minutes left.
So I always think, so I'll say it again, the questions are always much more interesting than anything I'll be able to say in response. So thank you all very much for these really interesting points. I mean, basically, I think I can address the points by addressing the question, how does EMU interact with social policy? So on the one hand, there's monetary policy and QE, and there's lots of interesting research on the regressive effects of QE, so it is also not immune from a social policy analysis. But what I mainly want to talk about is not QE, but the other two elements, which I think it's good to separate. One is the sovereign debt programs, which is what I was focusing on today, and the other is the European semester, because they're really very, very, very different. So, so in relation to the sovereign debt programs, I would say although, and this is a massive change for the EU, before the EU could genuinely say, we're not that involved in member states' social policy, and it was true. At the margins, sometimes little bits here and there, but largely speaking, they were not involved. And that is no longer, that can no longer be said. And that is a massive change in how people perceive the EU, and that is, it is normal that they perceive the EU differently. So that has big implications for how we proceed from now, because that period when the EU was not involved is over as a result of the sovereign debt programs. So although we can have interesting discussions, I mean, somewhat Jesuitical discussions, I have to say, about EU law, non-EU law in the sovereign debt programs, law, non-law, these are very interesting. But the fact is, the best reading of these programs is that they were all connected to EU law and EU institutions in different ways, with different reasoning, but every single one was. Now, so the blockages created in coming to that understanding were largely created by the Court of Justice itself. So in terms of resolving them, it is up to itself as well, but also scholars who call it out and say, come on. You know, so good legal analysis has its role to play here. So Aida said, but were all these measures really falling within Article 51, Paragraph 1 of the Charter? I would say nearly all. The most typical case is yes. And why is that? A, because many of them were specifically written in the MOUs. Many of the most problematic measures were written in the MOUs. And in those cases where that was not the case, we also have to think about the very wide approach the Court of Justice has taken to other areas of deciding what falls within the scope of EU law for the purposes of Article 51, Paragraph 1. For example, the Franzen case and so on. So my point here is the sovereign debt measures are EU law. The Charter does apply, and they are binding. So, you know, that is, so you can't say this is nothing to do with the EU and so on. It is absolutely 100% to do with the EU. And the citizen on the street fully understands that, and that is incredibly important. So it's not just a legal fact, it's also a social understanding of the EU's role in social policy over the last decade. So you might not have been living in Greece, but the Brexit discussions in the UK deliberately pointed to the EU as the creator of Greek unemployment. And they were not wrong, you know, so not that I am supporting their views or anything, or these people, but we have to acknowledge the EU got involved in heavily regressive social policy measures in a large number of member states for a long period. So that's the sovereign debt measures. Then we get to the European semester. So here there are two questions, both of which I answer no. Is it a regressive straitjacket? Is EMU doomed? So my answer is no. So I do not agree with you just can't escape its design flaws, you can't escape the fines, you can't escape no. I do not believe that is I do not see EMU working like that. So the country-specific recommendations, let's focus in on those. First, they have become way more social. I mean, read them since Juncker became Commission President. Read them especially since the Pillar came on board. They are dramatically altered. But does that even matter? You know, so I would say they're not very harmful, whatever they say, because they're almost entirely invisible. However, what is visible is the budget negotiations in certain specific contexts between certain member states. These are highly visible. So, I mean, if you live in Italy and you read the paper, or wherever you live, you see the discussions between the EU and Italy. So, what's important then is how the 6 and the 2-pack restructured these budgetary negotiations in a specific way that makes this a very visible, very high-intensity discussion between, it's still a diplomatic discussion, I would say, largely, but structured by legal institutions, and that's really important. So, what's happening then is the social part is basically invisible, non-binding but invisible, and what's visible is these hard negotiations on spending, which can reinforce this feeling of feeling estranged or Europe as an anti-social project. And this can be exploited, as it is in Italy, by Cinque Stelle and so on. You say, we would love to introduce our universal citizens' income, which is not very progressive either, but we can't, because look at so this is a very bad dynamic for the EU to be in. So my suggestion then, well, my suggestion with Bruno de Witte, because we wrote this short paper recently, which instead of coming to Barcelona with me, he has to go and present in Brussels tomorrow. So he's very upset and jealous. And so I had to communicate that, because I know he spent some time here and he's always saying how brilliant it was. So anyway, we've produced this little paper then saying there's no going back. Forget the EU should stay out of social policy. The EU is associated with social policy now. It cannot go back, or not immediately in any event. Is there any point putting lots of social stuff in the country-specific recommendations? Good idea, but it's not sufficient. So our paper is called A Tangible Human Face for Social Europe. So we say the EU needs to do something. So here we follow, accidentally, he follows us actually, Emmanuel Macron. So we say the EU needs to do something really visible so that all the citizens in Europe see it underpins social Europe. So forget what's in the treaties, think about what you need to do, and then find a way to do it. So it should provide a guarantee of a minimum income for everyone in Europe, a guarantee of minimum pay, and support inclusive collective bargaining structures to address inequalities in Europe, and promise to protect all vulnerable workers, especially those in the gig economy. So if you do that, then people think there's an underpinning. We are protected by Europe, and then the EU and Italy can have a discussion in which people will consider the Cinque Stelle proposals differently. So that's it.
Well, thank you all for this wonderful panel, and we hope you stay until tomorrow with us. So thank you, and let's go have lunch.